Hello everybody and welcome to Conflicts of Interest and Other Ethical Issues in Your Practice. Today we're going to be taking some time to go over some of the different issues that you'll come up to in your practice, both ethical, conflict of interest, and practical issues that you're going to deal with as an enrolled agent or other tax professional. We're going to talk about some of the ways that you can best address these issues and some of the ways that Circular 230, which is the IRS publication that tells us the rules governing those practicing before the IRS have to say about those things. So this presentation was created by Lifetime Resources. If you enjoyed it, please leave us a review or tell us about it. Make sure when you fill out this course, you download this course, to go and download the additional documents and review those. There will be a link to a quiz that you can fill out to be able to get your CE credit. So there will be a document labeled instructions for this course, so make sure to download that document, which will take you to the quiz. You'll fill that out and need to get at least a 70%, and as long as you get a 70%, you will pass the class and therefore be able to move on and get your CE credit. It does need to be done within 3 months of purchasing the course, so please make sure that you submit your quiz within 3 months of purchasing this course. All right, without further ado, let's move on over to conflicts of interest. That handsome guy there is me. As you can tell, I'm still me. My name is Jacob Weil. I am a Florida barred and licensed attorney, as well as an enrolled agent and a licensed community association manager. And I don't know if there's any other letters, notary public, a couple other things, I guess. I'm admitted to practice both in the Southern District of Florida and the United States Tax Court. I practice all over the state of Florida primarily, but I do transactional work with businesses all over the country, and I actually have clients all over the world, Curacao, Germany, so I have clients a little bit of everywhere. I earned my Bachelor of Arts degree from the University of South Florida, and I went on to Barry University's Duane Andreas School of Law. And my practice areas are primarily that of tax planning, business law, and such. So, with that, let's go over what today's agenda is going to be really briefly. We're going to go over an introduction and overview of what the materials are. That's what we just did there. We're going to talk about Circular 230 and what is Circular 230. We're going to talk about conflicts of interest. We're going to have engagements, agreements, and fees. We're going to talk about office rules and procedures. We're going to talk about closing out clients' files. We're also going to talk about personal problems and professional life. And we're also going to talk about potential punishments that someone might have. And we're going to then conclude. Well, normally we'd have a period for open questions at the end, as this is a downloadable course. There is none, but there is a space on your quiz to submit any questions that you might have. And we'll try to send out some answers to you if we're able to. So, without further ado, let's get into Circular 230. What is Circular 230? Well, Circular 230 is a publication that establishes the rules governing those who practice before the United States Internal Revenue Service. This includes attorneys, certified public accountants, enrolled agents, and other professionals who practice before the Internal Revenue Service. So enrolled retirement agents would also apply to this rule. But basically, Circular 230 is a document that's going to set out all the governing rules of those people practicing before the Internal Revenue Service. And so you're going to want to look there to see if there's any ethical rules or guidelines whenever you're going to make a decision. Your Circular 230 is a good guideline. Probably want to have a printed copy in a binder sitting somewhere. And while it does get updated occasionally. For the most part, most of the general rules stay the same. So you'll be pretty good once you know the rules and you have them down. And really, what this is about is integrating the rules into your practice. The rules that are in the Circular 230 are really well designed to help protect your practice from liability and protect it from potential problems. It's also really well designed to protect your clients. Good professionals don't want to do things that hurt their clients, so if you follow the rules in the Circular 230, even if you don't think they necessarily always make sense, you're going to be better off. Not to mention, failure to do so can result in punishment. So The statutory authority for Circular 230 was in 31 U.S.C. 330, and that statute authorizes the IRS to regulate the practice of representatives of persons before the Department of the Treasury. 31 U.S.C. 330A1 was where that was cited, so if you ever want to go look at the actual authority for Circular 230, that's where you would go look. The language that actually was codified now, this is a fun fact for you, was actually originally acted in 1884 as a part of the War Department appropriation for horses and other property lost in military service. So if you ever want a fun tax trivia fact to give out, Circular 230, which governs our ethical rules, was originally enacted with a bill that covered horses and other property lost to military service. But speaking in general, only CPAs, attorneys, enrolled agents, enrolled actuaries, or other enrolled retirement agents are allowed to represent clients before the IRS, according to Circular 230. Now, that's the general rule, and of course, there are some limited exceptions. So those limited exceptions include enrolled preparers who can represent during examination period for only certain returns. It also includes family members who are allowed to represent other family members, employees who are allowed to represent their employers, and officers who can represent their corporations in certain situations. So, but generally speaking, the only people who are going to be able to represent clients for monetary gain in front of the IRS are going to be attorneys, CPAs, and enrolled agents, or enrolled actuaries, or enrolled retirement plan agents. So, what is a conflict of interest? The headline of this course. We're going to talk quite a bit about conflicts of interest today, and by the time you're done, your head is going to spin with conflicts of interest. So what is a conflict of interest? A conflict of interest occurs when there is any division of loyalties owed to two different entities by the same person or firm. A conflict arises when one person or firm or another owes a duty of loyalty to two different entities whose interests may require different decisions or actions. So that is a legal dictionary definition that came for conflict of interest. We're going to go over a lot of different definitions of conflict of interest, but you're going to see that they all have an underlying theme. And that's this idea that you're representing two parties that have potentially adverse interests. So, let's briefly go over some of the different types of ways that conflicts of interest can arise. And this actually came from a very good piece that was called Ethics by Pervasive Method, that was published in the Aspen Law and Business Journal by Deborah L. Rode. And she identifies 5 common patterns that show up when you have a conflict of interest. So let's go through what those 5 patterns are so we can better identify conflicts of interest in our practice. The first one that she identifies is simultaneous representation, representing multiple clients in the same or related matter. The second one she identifies is successive representation, which is representing a current client against a former client in a related matter. The third, positional conflicts, which is representing a client whose legal position would adversely affect another client in a factually unrelated matter. The fourth is a practitioner-client conflict, which is representing clients in a context that their conflict of interest conflicts with the attorney, the financial professional, the tax professional, the other professional's own ethics or their own ability to make decisions, or their family members. And there's vicarious conflicts of interest, which is essentially when a firm is trying to represent two people who might have conflicting interests. Now, all of these types of conflicts of interest may be waivable under certain exceptions, but these are generally the types of conflicts that you're going to see. So let's go through a couple of examples of what might be different types of conflicts under each of these. So simultaneous representation. So for example, this is the common divorce example that you'll probably have as your most common reason that a tax preparer is representing two clients that have potential conflicts of interest. When your clients get divorced and they're going to go file their taxes, if they both want you to file their tax return for them, they both have potential conflicts of interest in terms of who's allowed to claim what deduction and things like that. There's also a conflict that they might find out information that you're supposed to keep confidential between you and just them, and so that's a potential risk and error that you would have to protect against. So that's one conflict of interest that might exist, simultaneous representation. Another area is successive representation. So that's representing one client against a past client. So for example, if you represented a business and you had all the information about that business, and then a little bit later the bookkeeper comes to you and they're getting stuck with a trust fund liability, and they want you to represent them against the business that you formerly did the books and accounting for. Well, that potentially could be a conflict of interest there, because you have information that you otherwise wouldn't have that could potentially harm your former client. Positional conflicts of interest exist. That is representing a client whose legal position could adversely affect another client in a factually unrelated matter. Again, so back to the divorce example. If you're representing two people in a divorce, it might be in an unrelated matter, their tax return, they've now been divorced, but if they're both wanting to claim the same child, that's a conflict right there, and that's something that you're not going to be able to figure out. So that's a potential conflict that exists. Practitioner-client conflict. So this is whenever you have a conflict with your client. So what your interest is differing from your client's interest. Anytime that you're in business with one of your clients, this has a high propensity to exist. So if you are the preparer and you're representing them in your preparatory capacity, but you have a investor interest as well in the business, that tends to be where these kinds of issues lie. In terms of preparation, typically there's not really any issue with that kind of action, and easily that kind of conflict can be waived. When it comes to representation, I would advise to be more careful if you're going to represent companies in which you have a financial interest in. There is nothing that stops you from being able to do a waiver on that kind of thing, but if you have a potential conflict, it's just something that you need to be wary of. Vicarious conflicts of interest. So that means that you and another person in your office might be representing two clients that have competing interests. Whenever this happens, it's very important that you either don't take one of those cases, or in the alternative, you can place what's called a Chinese wall in place. And what the Chinese wall just essentially does is basically separates and keeps all the data and information between you and that partner separate on that particular case. This can be a very difficult thing to actually accomplish, so it's not always the easiest thing to do. All right, now what about Circular 230? Well, in Section 1029, Circular 230 gives us information and rules and restrictions regarding conflicts of interest. And Circular 230 has at least two major potential effects on covered professionals when it comes to conflicts. Conflicts of interest, when it comes to those, there's first, if you violate Circular 230's provisions regarding them, you could be subject to sanctions under all of the different sanction rules, and we'll go over some of what the sanctions can be a little bit later in this video, though we're not going to spend a ton of time talking about what happens to you when you get in trouble. We're going to spend a lot more time keeping you out of trouble. And Circular 230 violations can also be used in a lawsuit against you. So if you conduct Circular 230 violations, conflicts of interest, that can be used to collect against your malpractice insurance. It can be used to collect against you personally in a lawsuit, saying that you committed an error, omission, malpractice, and some type of malfeasance or negligence by not properly representing your client. So, how does Circular 230 define a conflict of interest? Well, Circular 230 is very specific. It says a conflict of interest exists, one, if the representation of one client will be directly adverse to another client. Or two, this is an or, there is a significant risk that the representation of one or more clients will be materially limited by the practitioner's responsibilities to another client, former client, or third person, or by the practitioner's personal interest. So really, this is just the same thing we talked about a moment ago. This is explaining that a conflict of interest exists where you and another party or two third parties have conflicting views, conflicting interests, and you can't represent one necessarily without doing something that might adversely affect the other. You owe both of them the responsibility of care, and they both have competing interests. So, what does Circular 230 say about conflicts of interest? Well, in Section 1029, it says about representing clients with conflicts of interest that a tax practitioner shall not That's a shall not, you may not do this, represent a client before the Internal Revenue Service if the representation contains or involves a conflict of interest. However, being the rules, there's always exceptions. So, the exception is, you are allowed to represent someone with a conflict of interest only if all of the following three things are done. And you have to do each and every one of the following three things. Otherwise, you're in violation of Rule 230, or 1029, Circular 230. The practitioner must first reasonably believe that the practitioner will be able to provide competent and diligent representation to both the affected parties, all the affected parties to the client representing themselves. The second thing is that the representation cannot be prohibited by law otherwise. So if you owe other ethical duties to your clients beyond your enrolled agent status, then you're going to have those ethical rules barring you as well. So for example, I as an attorney, in addition to following all of these rules, have to follow all of my bar ethical rules when it comes to conflicts of interest. And if I don't meet those guidelines as well, well then that would be prohibited by law and therefore I can't do it. Likewise, there are certain state guidelines that limit professional conflict of interest, so you might want to look into your state guidelines. Finally, each affected client has to waive the conflict of interest and give informed consent, and that must be confirmed in writing by each affected client. At the time of the existence of the conflict of interest is known by the practitioner. They need to basically immediately reach out to the client as soon as they know about the conflict and that it exists, explain the conflict, and while best practice is then immediately to get something signed, the requirement is then within 30 days to have a signed document stating what the conflict is and how the conflict exists. So, copies of written consents must be retained by the practitioner for at least 36 months from the date of the conclusion of the representation of the affected clients. And the written consents must be provided to any officer or employee of the Internal Revenue Service on request. So, as far as this rule goes, there's no real defense on this one. If a conflict issue is raised, you're going to have to show that document. I recommend everybody make a digital copy of it and keep it forever. This might say 36 months on there. Digital documents nowadays, you have conflicts, make sure your documents are all encrypted and secured, but make sure that you're not going to catch an issue where you're potentially going to run into a lawsuit, because remember, even though 36 months may be the date for the IRS, your state liability statute on malpractice, laws may vary and may have a much longer statute of limitations than that. And many statute of limitations don't actually start until the discovery of the error is made. And so if you're representing somebody who has a conflict of interest and that conflict of interest eventually affects some later generation or party, for example, or you're representing an estate and there's a conflict that exists there, there's the potential that you could have 2, 3, 4 years down the road until the initial discovery should have taken place of the error, and therefore the clock doesn't start ticking until then. You want to make sure you're covered no matter what happens, so it's just a good idea to keep that always as a protective document for yourself. But what do you include when creating a conflict of interest waiver? Well, there's always the option of going to an attorney every time and having them draft one up for you. I recommend, if you're planning on creating your own, making sure you have an attorney look it over in your state to make sure that it is good for your state and meets all of your state's requirements. Accompanying this video, there will be 1 or 2 different sample ones that you can see in the video that you can type from your own, but we recommend really either going to see an attorney or using a standard form document and then manipulating it as you see fit. But understand, if you do not see an attorney beforehand, your chances are it's going to be a lot more expensive afterwards if there's a mistake in the document. If an attorney looked at it beforehand, now you have some recourse if there was a genuine mistake. Now, just because an attorney looks at it doesn't mean it's going to be perfect, and we can't anticipate every single problem. The idea of making a contract is to really create rules and frameworks for discerning how disputes are going to be decided. So when creating a conflict waiver, you're similarly doing the same thing. You're just showing that I don't have any conflict with you. Later on, you might have a conflict. You want to be able to show that there's no issue. You ever get sued, any family member ever comes, you had a contractual relationship with them, you explained the conflict of interest, and they chose to waive it. They understood the potential risks and chose to become involved anyway. That was their own fruition. So that's really what you're trying to message when you're creating a conflict of interest waiver. That they understand what's going on and that they are waiving their rights. So what do we include? We include the firm and professional information. So your name, your business address, your phone number, your email, your business name, etc. You include the client's information. You include a brief and general rendition of the facts, which have created a situation arising to the conflict of interest. A brief description of what the conflict of interest is and how it may have the potential for a negative impact on the representation. A brief description of how you'll handle the conflict of information from receiving from any competing interest, so how you're going to handle that information, and the signatures of both the professional and both clients. So when it comes down to this, it is a best practice to have this document signed at a conflict of interest meeting with both parties present and all signing simultaneously. If there is a high potential for liability or a large net worth complex client cases, you definitely want to make sure you have the document notarized as well. While it's not required, it does verify the authenticity of the signature and makes it a lot easier for you to actually enforce. Now, when it comes to conflicts, how detailed do you need to be? Be as detailed as reasonable. You don't need to give every single fact that exists in there, but you need to make it clear that you've had the conversation and they understand what the potential conflicts is and they have the ability to properly vet the decision. With that said, let's take a brief look at some different conflict of interest waivers that you might want to take a look at. All right. So I'm going to step out briefly so you can take a look at this first conflict of interest waiver. We'll just take a couple of minutes reading that over. You'll notice that this conflict waiver is a conflict and termination letter. So this is the type of letter that you would send to your client if you were terminating the representation based on this conflict of interest. Oh. So if you're terminating your representation based on the conflict of interest, this is the type of letter that you would be sending. Basically, there's a conflict of interest. I can't represent you. It's been a pleasure serving you. Good luck. Unfortunately, I can't represent you anymore. Of course, there's also some samples that you would want to take a look at if you're planning on continuing to work with the client. Always best to have all clients sign the same conflict waiver if you're representing multiple parties. If the conflict is with you yourself personally, then obviously it's just you and the client. But if multiple parties exist, then you want to make sure that all parties sign that conflict waiver. So as you can see, there's different ways that you can draft these, but they all really have the same basic components. Your information, the information of the client or clients that you're working with the potential conflict, what the potential conflict is, how the conflict is going to be treated, and then a location for signatures of all parties. Now understand, when I recommended that you notarize these documents, we're going to talk about notary rules when it comes to tax professionals a little bit later. You cannot notarize this document for yourself because you have an interest in it. So if you are a notary, you are not allowed to notarize this conflict of interest waiver for these people because of your interest in the document. If there's a member of your staff who is not a named employee, named partner, or actively involved in the conflict. So, for example, if you have a bookkeeper who has a notary who works on a different account, they absolutely can notarize the documents for them. But you yourself won't be able to notarize these conflict of interest waivers. I mean, because they signed it, it'll be just as good, but in terms of court recognition of the notary, in the state of Florida, it won't be valid. I imagine in almost every other state, similarly, it would not be. But you typically are not going to be allowed to notarize these types of documents as well. The IRS has certain rules against notarizing things for clients that you're actively working on. So, now that I've given you a moment to take a look at those documents, let's talk briefly about engagement agreements and fees. So, when you're using an engagement agreement, Circular 230 does not require anyone to use a written engagement agreement for client work. However, it's a bad idea not to. And why is it a bad idea not to? Because if you don't, the chances are you're not going to be able to collect from your clients if an issue does happen. And your clients are going to be able to say you promised things that you didn't, or ask for services that you didn't promise. So, what should you have in your engagement agreement? Well, you want to lay a couple things out. You want to lay out what the client is hiring you to do. This is the scope of your representation. You want to lay out how your fees are going to be computed. Is it a flat fee? Is it an hourly fee? Is it based on a percentage of the overall discount you're able to achieve? What is your fee arrangement? You need to be able to determine how their fee is going to be determined. Is it contingent based on some action that you are successful in? So where and how are any disputes to be resolved? Do you want to go to court, mediation, arbitration? Is there a particular locality? And make sure when you're including these provisions, you check what your local rules are. Your state may have particular rules, or your county may have particular rules regarding how professionals are allowed to limit their liability when it comes to conducting disputes. It's very popular to use a service from the American Arbitration Association as binding arbitration in all disputes that they offer. That's telephonic arbitration. Telephonic arbitration is great at cutting down money if you're sure that you're always right. The downside is the lack of discovery can mean that when you do make mistakes, the arbitrator is a neutral party, and that means you can very quickly get pushed towards having to pay out large amounts of money. So arbitration provisions are a double-edged sword, and you need to talk to a legal professional about whether or not you think that's the best practice for your business. So depending on the type of liability that you create, how often you create liability, what type of practice you have, it's advisable to do different things based on your risk profile. So that's really something that if you're not comfortable understanding your risk profile on your own and what the best course of action for you is, that you should probably talk to an attorney. But it can often be advisable and save court time at least to place a no contest, or not a no contest provision, binding arbitration provision in that document. Also, that's up to state law as well. What final expected work product is the client going to receive? So what are you going to be giving your client at the end of this engagement? When using an engagement letter, you should always make sure that your client does sign the engagement prior to you beginning the work. While the law doesn't generally require engagement agreement in most cases, depending on your state law it may, but generally speaking, under 230, you're not required to have one. Failure to have one will significantly limit your ability to show the scope of representation you are hired for in the event that a dispute does actually arise. So, here's a couple practice tips for you. When you're dealing with a client who is asking for additional work that's outside of your original scope, if you have a engagement agreement that you had them sign when you started doing it, that clearly lays out what the prices is for each service that you cover, you can always send back the engagement agreement with it and explain that your current payment is limited to that scope of engagement, and therefore, in order to make sure that you're properly protected and can provide those services, it would necessitate you signing another engagement, which requires additional fees. So there's always kind of an awkward conversation that happens with a lot of practitioners and their clients when it comes to telling people that when they're going to ask for additional work, that's going to mean additional fees. So having a written engagement agreement every time you take on additional work kind of makes the awkwardness of it go away, because I have to sign the additional engagement agreement so I can include it in there. And even if you choose to do that additional work for no additional cost, you could still sign an engagement agreement and say, hey, we're going to include this as gratis work for, the consideration of you being a good long-time client, whatever it might be. But you always want to update your engagement as you take on new work and scope of responsibilities. You can either have an ongoing engagement or a single engagement, I'm just preparing this 2019 tax return for you, or I am going to be representing you as your tax professional in an ongoing capacity, providing representation services and tax preparation services quarterly, etc. And as well, most professional malpractice and E&O policies actually have a requirement for you to have an engagement agreement, and if you don't, you won't be covered. So while you might have been paying those premiums, if you didn't use an engagement agreement for that particular case, the insurance company is going to say, whoops, sorry, you're not covered, as they like to do. Okay, so let's talk about some sample engagement agreements and just look at a couple of samples. This is a sample engagement agreement you might use for return preparation. Now, this is one of the longest ones I have seen. There's nothing wrong with long, there's nothing necessarily wrong with short. Now, if you're going to have a really long engagement agreement, some clients tend to get wary. I say 2-3 pages at the most. Honestly, for a simple tax return engagement agreement, if you're just doing one tax return, it's easy to have a form that you've generated that you check off a box, and when the client comes in, just have them sign it that states all your terms, and that acts as an engagement agreement. You don't even have to do anything special. But this is a good example of a nice long form engagement agreement that goes through all the different information that you might want to see that you can use as an example. Here's a sample advising agreement that you might want to take a look at. This is more of a consulting type engagement agreement in terms of giving advice, tax advice, and business advice. Many of us, in addition to preparing returns and representing people before the IRS, are advisors to many of our business clients, many of our individual clients. Part of that can be doing legal or tax research regarding the tax code, presenting that to our clients. So these types of advising engagement letters are useful if you don't necessarily know what all you're getting into. Sometimes you do it at a flat rate. This example is a flat rate example. So the client's looking for an FDD to be reviewed here and some tax advice on the FDD. Here's the scope of what it's going to be, and it's going to be a $1,500 non-refundable retainer to cover all of these things. That covers a 120-day period, and after 120 days we need a new retainer. Anything outside of those things, written work product, is obviously additional according to this engagement. So it just lays out very well, simply for your client, what they should expect and prevents disputes that way. And here's another sample tax examination engagement letter that you could use if you're representing someone before the IRS. This is a good one to use, but you'll, like I said earlier, see the client name, the information of what you're planning on doing, where you're representing them, what they're going to be paying you, your information. All of these things are going to be included on there. No matter which one you decide to use, make sure you look it over, read through your engagement, and know your engagement agreement. Make it easy for your clients to understand. It does not have to be in legalese. If you find an attorney who just wants to put legalese provisions all over your engagement agreement so that no one can understand your engagement, you probably should find another attorney because these things can be written so that the average person can understand them, not so that you need an advanced law degree to be able to understand them. Now, when I say the average person, that's probably someone with a high school graduate level education. That level of type person should be able to read your engagement agreement and understand what every provision of it is saying without you having to explain it to them. Now, the rules regarding fees. Now, Circular 230, Section 1027 says, generally speaking, every professional has a great deal of discretion in terms of how they are allowed to set their fees, how much they're going to charge, how they're going to accept payment, and how and when they're going to get paid. But there's one important rule to remember, and that's that you cannot charge a fee that would be considered unconscionable in connection with any matter that's before the Internal Revenue Service. Now, unconscionability is a wishy-washy term because it simply means that it's egregious, it's offends the senses, so to speak. So if, for example, somebody came in and asked you to prepare 3 years of back tax returns and it was a relatively simple preparation, there was no back taxes owed, in fact they were going to get a small refund, but you told them that there's a couple ethical problems that be here, but you told them that, hey, back tax, it's against the law to not file your tax return. This is a very complicated case. I'm going to file these 3 back tax returns for you, and it's going to cost you $50,000, but because I'm filing these tax returns for you, you're not going to be able to get in any trouble. You broke the law by not filing your tax returns. Well, that kind of deal would be unconscionable. If you extorted somebody that way by making them feel like they were going to go to jail if they didn't pay you this obscene amount of money. I mean, not only is it the fee unconscionable by being so large for the work that you're actually conducting there, but the practice itself is also a serious professional issue. Unconscionability is an aspect of any act, statement, or agreement that is contrary to a good conscience. As a general matter, it is contrary to public policy of the courts of the United States to enforce a claim that is based on an unconscionable action or arising from an unconscionable arrangement, when the enforcement, recognition, and enforcement of an unconscionable arrangement or act happens. So, what is a contingent fee? A contingent fee is any fee that is based in whole or in part on whether or not a position is taken on a tax return or filing that avoids challenges or the Internal Revenue Service or is sustained either by the Internal Revenue Service or litigation. A contingent fee includes a fee that is based on a percentage of the refund or reported on the return, and that is based on a percentage of the taxes saved or that otherwise depends on a specific result attained. A contingent fee agreement is also considered any fee agreement in which a practitioner will reimburse the client for all or any portion of the client's fee in the event that the position taken on a tax return or other filing is challenged by the Internal Revenue Service or is not sustained, whether pursuant to an indemnity agreement, a guarantee, rescission rights, or any other arrangement with a similar effect. So if you have any formal arrangement with your client that says, if this doesn't work, then I'm going to refund you your money, then you're taking a contingency fee. So what are the rules regarding contingency fees? Well, a practitioner may not accept a contingency fee for services rendered in connection with any matter before the Internal Revenue Service. Again, always exceptions, except a practitioner may charge a contingent fee for services rendered in connection with the service's examination of or the challenge to either an original tax return or an amended return or claim for a refund or a credit where the amended return or claim for a refund or credit was filed within 120 days of the taxpayer receiving written notice of the examination of or written challenge to the original tax return. A practitioner may charge a contingent fee for services rendered in connection with a claim for credit or a refund solely in connection with the determination of the statutory interest or penalties assessed by the Internal Revenue Service. So, only insofar as that you are able to show that the statutory interest and penalties are incorrect or improper, are you allowed to collect a contingency fee. That's the only portion that your contingency fee can be related to in that instance. And a practitioner may charge a contingent fee for services rendered in connection with any judicial proceeding arising under the Internal Revenue Code. So if you are representing your client within the tax court as a judicial proceeding, and that means that it can be a contingency fee if you would like, as long as it doesn't otherwise violate your ethical rules under the United States Tax Courts Bar or the Florida State Bar, or whatever bar that you are a part of. So, a little bit more about contingency fees. A practitioner may not charge a contingency fee for services rendered in connection with any matter before the Internal Revenue Service, except for services rendered in connection with the services of examination or challenge of the original tax return. I feel like we went through this. Practitioner may charge a contingent fee. All right. So what about office procedures and rules? Well, there's a lot of different office procedures and rules that are outlined in the Circular 230 document. So let's talk about some best practices when it comes to providing advice according to Circular 230. Tax advisors should provide clients with the highest quality representation concerning federal tax issues by adhering to best practices in providing advice and in preparing and assisting the preparation of or submission to the Internal Revenue Service of tax returns or other information. Best practices should include the following: communicating clearly with the client regarding the terms of their engagement and what they should expect. That goes back to engagement agreements. Establishing the facts, determining which facts are relevant, evaluating reasonableness or any assumptions or representations relating to the applicable law. Advising the client regarding the importance of conclusions reached, for example, whether the taxpayer may avoid accuracy-related penalties under the Internal Revenue Code based on the advice that they're given. And acting fairly and with integrity anytime you practice before the IRS. Number one on that rule is never, ever, ever lie to an IRS agent. You don't always have to tell the IRS everything, and in fact, most of the time you shouldn't. But you should never, ever, ever not tell the truth to an IRS agent. You are a representative. If you don't know the answer to a question, or if you need to get confirmation on something from your client, you can say, I need to get more information from that on my client, or at this time I need some more authorization to be able to give you that information. But don't ever lie to try to cover something up. It's just a bad idea, and you will get in trouble. That's part of that acting fairly and with integrity. And it's a very good way to try to make a IRS agent angry. And when they get angry, they like to start to seize things. It's a very bad idea to make someone who has the power to seize your client's stuff angry. Ways to make sure you're keeping up with those best practices. Have a communication plan. How do you communicate with your clients? Are you planning on emailing, phone, text, fax? How are you planning on keeping up with what's going on with them, with their information, etc.? Do you have a fax sorting system? Do you have forms and intake sheets that you're using to create and identify and understand important facts? You need to create a list of questions that tend to help elicit the facts that you need from your clients and use those in your practice. Have a written disclosure regarding any advice you get. What assurances are you providing, and what waivers or disclaimers are you providing? Are you guaranteeing any of your advice? Most of us don't want to promise that if people rely on what we say that it's 100% going to be true all the time, because the truth is 99% of the time the client doesn't tell you everything, and for some reason that one little iota they decided wasn't that important was the one thing that you really needed to know. So it's all very important information to understand. For example, I recently had a client that came in who, after we were trying to do an offer and compromise, she asked me, was it a big deal whether or not her grandfather had just died and she was planning on getting about $300,000 as soon as they finished selling everything off in the property. Well, even though I asked all those questions beforehand, doesn't necessarily mean that that information was elicited. So you need to basically give your clients baby steps every step of the way. That way you can get the information that you need. Luckily, we hadn't submitted the offer already in that case, and we were able to go back and figure out what we needed to do. So it wasn't really a waste of time, but understand that there are certain things that you need to make sure you're doing and staying on top of when it comes to communicating with your clients. So you need to know how to elicit the information that you need from them, and part of that is looking through questionnaires that other professionals have prepared, and part of that is professional practice. And as you have come to experience more cases and interacting with clients, you'll start to know what better brings the information out that you need. You need to have a written disclosure regarding any advice you're planning on giving. That needs to explain what assurances you provide and any waivers or disclaimers you may want to give. Now, tax professionals with oversight responsibility. If you are a tax professional and you have oversight responsibility, it is your responsibility for overseeing the firm's practice and providing advice concerning federal tax issues, or preparing or assisting in the preparation and submission of returns or other information to the Internal Revenue Service. You should take reasonable steps to ensure that the firm's procedures for all members, employees, etc., are consistent with best practices. So understand that the IRS, if you are in charge of a firm, looks at you as in charge of that firm. They are not going to accept that, well, this other professional that I hired, who I told that they should do it, I put them in charge, so it's okay. If you have oversight responsibility and control as a professional, you need to use that oversight responsibility to basically protect the people. So, what about providing written advice? Circular 230 says that there's a standard of review for written advice, and that is that of a reasonable practitioner. Whenever you are providing written advice, you must do so from the standard of a reasonable practitioner providing such advice. Practitioner may give written advice concerning one or more federal tax matters subject to the requirements. under section A2 of 1037 of Circular 230, if you want to look up the information, which basically says when a provider is providing written advice, the practitioner must base the written advice on reasonable, factual, and legal assumptions, that they need to include what those assumptions are based on. They need to reasonably consider all future events and circumstances that the practitioner knows or reasonably knows is likely to occur. So a good example of that one is providing written advice with regards to the current legislation on estate taxes. If you're providing written advice to your client that they don't need to worry about estate taxes because their net estate is about $9.5 to $10 million and there's currently $11.4 million exclusion, well, you sure as heck want to include in there that provision sunsets in 2026 and there's a potential risk that it will go back down to the $5 million adjusted for inflation number after 2026. Now, is that necessarily going to happen? We don't know, but you want to make your client aware of that potential risk and to know that they need to be on the lookout, and why, while this plan is good until 2026, if this change does occur, they want to make sure that they're aware of those potential issues. If you don't provide that information, you're going to be caught on the hook when in 2028 when they pass away and they end up spending an extra $250,000 on estate taxes because they thought they had an $11.4 million exclusion and Congress lowered it, or Congress didn't renew it, that those issues are going to happen. Now, obviously, you're not going to be able to know everything that occurs in the future, but everything that's reasonably foreseeable for you to know that there's a potential risk to a strategy that you're advising a client to use, you need to disclaim that information so the client can make an informed decision on their own. Your job is not to make decisions for your clients. Your job is to present your clients with all the information that they need so that they can make an informed and educated decision on what they would want to do to go forward, and to present them with solutions on what you think that best decision to move forward is. You can advise your clients, but you should not be making decisions for them. You also need to use reasonable efforts to identify and ascertain facts that are relevant to the written advice on the federal tax return. In addition to that, you can't rely on representations or statements or findings or agreements, including projections or financial forecasts or appraisals of the taxpayer or any other person, if the reliance on them would be unreasonable. Related applicable tax law and authorities to facts. You have to show how you're applying law to the facts. Very much this is a process of going and identifying the law and putting them in a facts-based scenario. And you need, in not evaluating a federal tax matter, you have to take into account a possibility that a tax return will not be audited or that the matter won't be raised for audit. So you can never, ever, ever, ever provide written advice that says, well, there's a good chance that this won't be audited. That is not a reason for advice. The fact that you can slip under the radar and break the rules doesn't mean anything. So you always have to provide advice under the assumption that you are going to be audited, and that's simply the rules under Circular 230. And the reason for that is, if you're trying to scheme on things, the IRS has, a couple thousand agents that are investigative agents. They have, a few thousand people who are investigative internal personnel and support staff that handle those things. But for the most part, their investigative branch is already overwhelmed with the matters that they do have. Can you imagine if we were providing advice that said, hey, you're not going to get caught, so it's okay? That's really the rule for that. So a little bit more about providing written advice. You need to, if you're relying on the representation statements, findings, or agreements as unreasonable, if the practitioner reasonably should know that one or more of the representations or the assumptions in which the representation is being made are incorrect, incomplete, or inconsistent. So if you know that there is inconsistencies in a story, in the law, or something, you need to be able to present that and show that there's some inconsistency. So that's whenever you're doing that type of legal research, it's very important to do that. And this type of tax research really is legal research. In terms of where you're going to be able to do this type of research, Thomson Reuters makes some great tax products, their Tax Pro products. Lexis Advance makes some great tax products. There's a lot of different options out there. You can go look into the code sections. If you're going to be doing a lot of this, though, I suggest getting a platform to use as your research tool. A practitioner can only rely on the advice of another person if the advice was reasonable and if the reliance is in good faith, considering all the facts and circumstances. Reliance is not reasonable if the practitioner knows or reasonably should know that the opinion of the other person shouldn't be relied upon. So if you know that person is untrustworthy or dishonest, you shouldn't rely on that opinion. They know that the person is incompetent or lacks the necessary qualifications to provide the advice. So if you're planning on relying on your neighbor Joe the plumber who said the one time that he talked to the IRS they said this, that's not going to work. And the practitioner knows or reasonably should know that the other person who has a conflict of interest in violation of the rules described in this part. So the practitioner has to know, if the practitioner knows or reasonably knows that the other person has a conflict of interest in violation of the rules that are described here, then you can't provide written advice on that. What about the rules regarding notaries? I said briefly a little bit ago that there's some rules in Circular 230 that pertain to notaries and what you're allowed to notarize for your clients. Well, Section 1026 gives us some guidelines on notarization. And it says a practitioner may not take acknowledgments, administer oaths, certify papers, or perform any official act as a notary public with respect to any matter administered by the Internal Revenue Service and for which he or she is employed as counsel, attorney, or agent, or in which he or she may be in any way interested. Now the key word there is practitioner. So that means if you're the person or your firm that you own is representing a client, you are not allowed to notarize documents that would be going to the IRS. However, if you have office staff in your office, bookkeepers, simple return preparers, administrative assistant, receptionist, etc., they can be notaries and they can notarize the documents for you. They are not a practitioner in the eyes of the Internal Revenue Service Code. They are not a practitioner under Circular 230, and therefore they can notarize your documents for you. So while you can't notarize documents that you're sending to the IRS for your own clients, you can have someone in your office who does. So what about staff or other employees? As long as your staff or other employee is not acting in a tax professional representative capacity, that staff member can notarize the documents for your clients. Moreover, you may notarize the documents for other professionals in your office as long as you don't have any representative or relationship capacity to that client. Now, if you are the owner of your practice, by definition, you technically have an owner-client relationship with all of the clients at that firm, unless and until that firm has become so large that there is no longer a direct impact relation and you would no longer be at the point where you're seeing clients in that matter, in which case you might be able to argue you're getting away from that. But the smaller your firm is, the less likely you're going to be able to run into that. So my advice is normally on any tax documents, just let your receptionist, assistant, whatever, notarize your documents for you. Now what about closing out a client's file? Whenever we're closing out a client's file, it's important to do certain things. Under Circular 230, it says that a practitioner must, at the request of a client, promptly return any and all records of the client that are necessary for the client to comply with his or her federal tax obligations. Now what if the client hasn't paid you? Doesn't matter. You've got to return everything if they ask for it. Practitioner can maintain a copy of the records that they return to the client if they'd like, though. And the existence of a dispute over fees generally, like I said, does not relieve the practitioner from his or her responsibilities under this section. You still have to give the money back, or give the paperwork back, even if they don't give you the money. You can't say, I'm holding your paperwork hostage until you give me my money. However, there are certain state laws that allow or permit the retention of a client's records by a practitioner in the case of a dispute over fees that's being rendered. A practitioner only needs to return those records that must be attached to the taxpayer's return in that case. The practitioner, however, must provide the client with reasonable access to review and copy any additional records the client might need, and must, as necessary under state law, comply with any other rules and obligations. Now, this is a bad practice, though, and not recommended. If you're going to force your clients who don't pay you to come in and get their documents, it's going to lead to a lot of negative reviews, a lot of bad publicity, and it's If you're going to deal with it by sending them to collections, they owe you money, deal with it in that matter. Don't try to hold documents hostage. It just doesn't put you in a good position ever. Now, written confirmation from return records. While not required by the rules, it is always best practice to always prepare a written document confirming the return of any records to your former client. So whenever you do that, you should include a couple things. The client's information, a list of the documents that you are returning or whatever items you're returning to them, a list of any client's documents which will be retained, electronically or otherwise, date the records were returned, client's signature showing acceptance, and you'll want to make sure you keep this file in your digital file. You have to keep it for at least 36 months, of course, but I recommend just keep it forever in your digital file after you've closed out the case. Now, sample records return example. Here's a very simple example of a sample records return request. I'll let you take a look at that for a moment, and I'll be right back. Okay, so as you can see, this is a nice simple document. It has the client name, client number, whatever client identifying information. It states, on this date, the following records were returned to this client. Here's a list of all the records that we returned, and that we're going to continue to maintain the following records. So if you're keeping any records, you want to make sure to include that. The company name or the individual name, either way, and then you want to make a disclosure that says, well, we're returning all these physical records, we're going to keep electronic copies unless you explicitly request that we don't. And if an explicit request is made that they don't, make sure you get that in writing and keep that in your file, and keep any documents that you need to protect yourself. So while you want to get rid of any documents that they request that you get rid of, you make sure that you keep anything you need to protect yourself from any liability. What about personal problems in professional life? Under Circular 230, you need to be competent in order to engage in practice. Now, what does competence mean? It doesn't merely mean you're able to pass your EA exam. It means that you actually are able to provide good representation with knowledge and competency and good acts to your client. You need to be able to well represent your clients with your knowledge, your skill, your thoroughness of preparation on their behalf. Competence of practice requires knowledge, skill, thoroughness, and preparation for a matter in which the practitioner is engaged. And a practitioner may become competent for a matter in which the practitioner has been engaged through various different methods. They can consult with other experts, they can read, they can study the law. So you, because you're not competent now to take something on, does not mean you can't be competent tomorrow. So if a client comes in and says, hey, I have this issue, and you say, hey, sounds like a great issue. Let me get back to you tomorrow before we sign an engagement agreement. I need to do a little bit of research first. Well, once you've done that research, you've now become competent, but you shouldn't be taking on the engagement until you are competent that you can handle that type of representation and that you are sure that you have that competency. In addition, and this is particularly important as there's been a general aging among the EA population. I tend to be on the quite younger side of the EA population. Whenever I go to EA conventions, I get, hey, who's the kid over there? I promise I'll only look like I'm 12. But the reality is the EA profession as a whole is starting to age. And because of that, we're seeing an issue with cognitive declines in cognitive ability among some of the older practitioners in our profession that are unwilling to step back from their role and not realize that they can no longer necessarily provide that same level of competent representation. So I am not someone who's ever going to tell somebody that they have cognitive memory recall issues. I'm not a doctor and have no way right to diagnose that. However, if you start to see or notice cognitive decline, understand that these rules are made to protect your clients, and you're putting your clients' well-being in jeopardy, and you're putting your own estate and personal life into a huge amount of risk and jeopardy. So that's just important to understand. So what about potential punishments? we're going to go over some of the potential ways that you can be punished under the Circular 230 rules. Well, there are sanctions. Under Circular 230, Section 10.26, the Secretary of the Treasury or delegate, after a notice and an opportunity for proceeding, may censure, suspend, or disbar any practitioner from practice before the Internal Revenue Service if the practitioner is shown to be incompetent, disreputable, and fails to comply with the standards, or acts with the intent to defraud, or willfully, knowingly misleads or threatens a client or prospective client. The Secretary of the Treasury is allowed to delegate, after notice, the opportunity for the proceeding and may impose a monetary penalty on the practitioner who engages in such conduct subject to sanction. So if a practitioner was acting on behalf of an employer or a firm or other entity in connection with giving the penalty, conduct that gives rise to a penalty, the Secretary of State or the Treasury may impose a monetary penalty as well on the employer, the firm, or the entity if it knew or reasonably should have known of the conduct. So being an ostrich is not an excuse as far as the IRS is concerned. Do not stick your head in the sand in your practice. As you're hiring people, you need to be involved and know what's going on. You need to understand what's going out. Now, it's a different story if somebody in your office, for example, embezzles and commits fraud and is committing a well-created fraud. If you shouldn't have noticed or known, you're not going to be penalized by the IRS for being defrauded. But if the reason that you were defrauded by your bookkeeper who you let handle all of the books for your account is because you went the last 3 years without looking at the bank account and now money has been transferred out for 3 years slowly but surely, and she's been doing it for all that time, that's a different story. You were an ostrich at that point. You should have known what was going on. You have a responsibility over your firm to make sure those kinds of problems don't happen. So understand that this is not an opportunity to try to hurt professionals who are already being hurt by their employees, but it's trying to make sure that professionals make sure that their employees are doing what they're supposed to be doing and have some type of liability and responsibility over their actual firms. The amount of the penalty shall not exceed the gross income derived or to be derived from the conduct giving rise to the penalty. So you're not going to be fined typically larger than the amount that you were making off of whatever the advice that you were giving was. So, the sanctions section include both monetary and punitive actions that are in the discretion of the department. The Internal Revenue Service is allowed to accept a practitioner's offer and consent to be sanctioned in lieu of being punished under the preceding section, Section 1060, which highlights all the punishment areas. Now, if you consent to be sanctioned, that is basically consenting to the wrongdoing of the IRS. It means that they don't have to go through the whole rigmarole of proving your wrongdoing. Typically, that means that you're going to get some type of lesser sentence. But on the other hand, that also means that you're going to see not have your rights to be able to defend yourself, so to speak, and that will go on your record. The sanctions imposed by this section shall be taken into account in all relevant facts and circumstances as well when determining what sanctions are going to be taken. So basically, they're going to consider the whole picture whenever they're implementing sanctions. Briefly, let's just go over incompetence and disreputable conduct according to Circular 230. So Circular 230 also allows for punitive action to be taken by the Internal Revenue Service Office of Professional Responsibility in the event that any of these actions occur from a professional. Pretty much most of them are going to be self-explanatory as to why, but if you have a conviction of any criminal offense under federal law, if you have a conviction of any criminal offense involving dishonesty or breach of trust, if you have a conviction of any felony under federal or state law which the conduct renders the practitioner unfit. So, for example, if you violated a federal law and that federal law was that you went and shot up a bank, you probably are not a fit person to be a practitioner in our profession. So we're going to remove your professional capacity to act. If you've been found to be giving false or misleading information or participating in any way to giving false or misleading information to the Department of Treasury, any officer thereof, that goes back to, like I said, never, ever, ever lie to the IRS. Never. ever lie to the IRS. It will get you in more trouble than you know what to do with. Solicitation of employment as prohibited under 1030, or the use of false or misleading representations with the intent to deceive a client or prospective client. Willfully making false federal tax return violations. Willfully assisting, counseling, or encouraging prospective clients to violate the law in some way. Misappropriation or failure to promptly remit funds received from a client for the purpose of payment of taxes. Directly or indirectly attempting to influence or offering or agreeing to attempt to influence the official action of any official or employee of the Internal Revenue Service. So I want to highlight number 8 for a moment, because many professionals use impound or impressed funds accounts and ACH their clients' quarterly payments to the IRS, tax payments to the IRS into their account, and then pay out to the IRS perhaps employment taxes and those types of things on their employer's behalf. Understand, you have a large amount of liability for that, and you're going to be on the hook for it all personally. And if you misappropriate any of those funds ever, those are client funds, those are not your funds, then you are going to be feeling the full wrath of the United States government for theft. And that can be definitely a wrathful experience. So, a little bit more about incompetence and disreputable experience. They listed a lot of things. Disbarment or suspension from practice as an attorney, certified public accountant, or an actuary. So if you are removed from a professional setting by any state bar organization or professional organization, you have the ability to be found incompetent and disreputable by the IRS and therefore sanctioned or removed from being able to practice. Now, for example, as an attorney, if I were to be disbarred, that would hinder my ability to continue to practice as an enrolled agent. So make sure you're maintaining all of your professional responsibilities, not merely your enrolled agent responsibilities, because it's not like you can just fall back on being the enrolled agent if things go wrong and you committed violations on your other areas. Giving false opinion, knowingly or recklessly through gross incompetence. This includes an opinion which is intentionally or recklessly misleading, or engaging in a pattern of incompetent opinions or questions arising under the facts of the laws. This one's a little harder to prove, but basically if you just keep giving reckless bad advice, you're going to run into some issues. Willfully failing to sign a tax return prepared by a practitioner. So if you willfully fail to sign a return that you're supposed to sign as having prepared it, then that's going to be an issue. Willfully disclosing or otherwise using tax return or tax information in a matter that is not authorized by the IRS code and contrary to judgments, the law, etc. Willfully failing to file on magnetic or other electronic media a tax return prepared by a practitioner when the practitioner is required to do so by federal tax law, unless the failure is caused by reasonable cause. Willfully failing to prepare, or willfully preparing all or substantially all or signing a tax return or claim for a refund as a petitioner does not possess current or otherwise valid prepared tax identification number or other prescribing identification information, or willfully representing a taxpayer before an officer or employee of the Internal Revenue Service unless the practitioner is authorized pursuant to this part. So if you represent somebody before the IRS that you're not legally authorized to represent, that jeopardizes your ability to practice. So if you get a call from a parent who wants you to help them out with their child's tax problem, until the child signs a written engagement agreement with you that hires you, you are not to do anything on their behalf, because that's a different, now if the child's under 18, obviously that's a different scenario, but an adult child needs to make their own decisions and hire your services first. You cannot represent someone who you don't have an engagement relationship with. So what about reporting practitioners' violations? So there's some people who have to report violations and some people who don't have to. If you're an officer of the or employee of the Internal Revenue Service, you are required to report any violations. Now, if you're anybody else, so you don't work for the IRS or the Department of the Treasury, you may make a written report anytime you want. So, if you define something out in your office that was done incorrectly or improperly, you are not going to be required to go to the IRS and tattle on the rest of your office. But you need, once you discover any of those problems, to immediately address them and solve the problems. This provision is made to not to encourage people to conspire to hide issues, but to encourage people to not be afraid to address issues that come up within their practices. No reports are going to be maintained unless the retention of the report is permissible under the applicable records and schedule is approved in the National Archives and Records Administration and is designated by the Internal Revenue Manual, and reports must be destroyed as soon as permissible under the applicable records control schedule. So any report as to your that was made against you, if it was found basically to be unreasonable, unfounded, then that report will be destroyed as soon as the law allows and as soon as it's reasonable after the conduction of the investigation. So, what disciplinary proceeding rules are there? I'm going to briefly let you guys take a look at this, just that you know where you can go to look for the disciplinary proceeding rules should you ever partake in one of those, but that's not the main focus of this course. We're not going to focus on how to deal with being in trouble. We're going to focus, like I said, we focused on how to stay out of trouble. But as far as the disciplinary rules go, Circular 230 Subpart D says that they have to have proceedings, there's rules for conferences, the contents of the complaint, discovery, hearings, evidence, how the transcript has to be done. So if you ever are curious or are involved in a disciplinary proceeding, or you have a colleague who's involved in a disciplinary proceeding and how that action actually works, go and review the Circular 230. It has a lot of that information on how the proceeding has to work and what the IRS needs to do. And what the Office of Professional Responsibility needs to do in investigating. So make sure that you review this if you ever need it at any point. Important information to know. What about the effect of disbarment, censure, suspension? What does that do? Well, a disbarment means that a practitioner will not be permitted to practice before the Internal Revenue Service unless or until authorized again by the IRS. A suspension means that the practitioner will not be permitted to practice before the IRS during a period of suspension. That's for a fixed period of time. For periods after the practitioner suspension, they may be subject to other conditions as well. Censure means that the practitioner is going to be permitted to practice before the IRS, but the respondent's future representations may be subject to certain conditions, and there's going to be a basic public reprimand that exists on the record. Now, what conditions are they allowed to impose? After being subject to a sanction of either suspension or censure, the future representation of a practitioner so sanctioned shall be subject to the specifications and conditions designed to promote high standards of conduct. These conditions can be imposed for a reasonable period in light of the gravity of the practitioner's violations. For example, conflict of interest or failed to obtain a client's written consents, then the practitioner may be required to provide the Internal Revenue Service with a copy of all the consents obtained by the practitioner for an appropriate period of time following the censure, whether or not they consent or are specifically requested. So the IRS could say, you failed to submit these documents properly for this period of time, you're receiving a censure, we don't think it's bad enough that we're going to kick you out or anything, but from now on you're going to have to send us for the next 3 years every one of these things that comes in every time so that we can look over it and make sure you're being okay, and they're allowed to do that. So, how do you search for disciplined tax professionals? If you go to the IRS website, there is a page that says search for disciplined tax professionals, and you're going to want to click on disciplinary lookup. There's an arrow there that shows you the place to click, but you'll click there and that will show you all of the disciplinary lookup. Now, what happens if you've been disciplined? Well, your name ends up on a list that looks like this, and this is just the A's. As you can see, there are thousands and thousands of people on this list, and you do not want to be on this list. And that is public record, so any person who wants to find that can. I advise you to inform your clients of the fact that they have this ability. If they're planning on hiring a tax professional, if you meet a prospective client, encourage them to run any person that they go to by this database just to make sure that they're not doing something they're not supposed to do. Also, a helpful thing on the IRS website is all of the disciplinary sanction records, the IRS bulletin records for disciplinary sanctions. And what those do is they go through And whenever there's a sanction that's issued, there's going to be basically a publication that's put out that explains what happened, why the sanction was done. So those are going to be done in the form of bulletins, and if you look there, you'll see that there's that section right there. You also have the Circular 230 tax professionals linked to there, and the Office Professional Responsibility at a glance. So all of those things are designed there to help you. So what do those bulletins look like? Well, those bulletins basically look like a real long list of everybody who had anything go wrong against them. And they go through and they explain a little bit about the facts of what they violated, and that way you can know what issues happened. If you ever want to enjoy an interesting time, just go read some of these stories, and you will laugh at what some practitioners apparently think is acceptable, or I guess think that they can get away with. They're also going to put a by state list in each one of those that tells you what's happened to each of the practitioners who's licensed before the IRS and what is allowed to happen from that. Now, for example, you'll see that there's this first page. It has all of those beginning of that list, and looks like we've got a couple people who just recently received indefinite suspensions. So now, normally this is a time when we go over questions, but I will tell you guys a little bit about how you're going to be able to get your CLE credit. When you go to get your CLE credit, there was a download with this video that included a paper that said instructions to apply for CLE credit. There will be a link to a quiz that is in that video. You'll want to make sure within the 3 months of downloading this video, you go ahead and take that information and click on that link and fill out the quiz. You got to get at least a 70% or higher in order to be able to get the CLE credit or CE credit, but you can retake that quiz as many times as you like with no additional cost. But there is only one quiz per person that pays, so if 4 people in your office want to watch this video, then 4 people need to make sure they pay the fee, otherwise we're not going to be able to submit all 4 PTIN numbers. A little bit more information, when you go ahead and submit that, within about 2 weeks' time you're going to get a return with a certificate of your completion showing that you have indeed completed this course. That information might be helpful to you. There will be a place on that quiz to be able to submit any questions that you might have so that we can go over that information with you. When you submit those questions, one of 2 things will happen. Typically we'll either respond in an email, or more than likely we'll eventually create a video answering your question and send you a link to that we'll post on the website as well. We appreciate any questions, comments, feedback that you have. And the later part of that quiz online, you're going to see an evaluation section. Well, that section is not required. I do highly encourage you to please take that section and let us know how you enjoyed this presentation, what types of presentations you'd like to see in the future, and what we can do to improve the quality of our continuing education. Prior to taking that quiz, I encourage you to spend the next 15 to 20 minutes just reviewing over those PowerPoint slides and looking through each one of those sample engagement agreements. Take some time to make some notes and highlights, and take some time to independently make sure to mark down and notate what areas that you want to basically bring into your practice. And then go ahead and take that quiz and qualify for the 2 hours of ethics credit. Typically those will be submitted once a week to the IRS, and like I said, within about 2 weeks you'll receive your certificate back. Thank you very much for watching this presentation from Lifetime Resources on the ethics and conflicts of interest that you might face in your practice. We hope you've enjoyed this practice presentation, and we hope that it helps you in your practice. So if you enjoyed conflicts of interest and other ethical issues in your practice, please send this video out and the link out to download out to any other professionals or tax professionals that you might know that need the EA credit. We hope that we can help you out, and please, if you have any questions or concerns, please don't hesitate to reach out to us. We are also offering live classes, so keep a lookout on our website for when live classes are going to be offered and available. They will be located in our home office here in Fort Lauderdale, typically, although we are available for private courses if you'd like to have us come into your office. for an additional fee, or if you'd like us to speak to your event or organization of tax professionals, we're more than happy to do that as well. So, like I said, we hope you enjoyed this presentation of conflicts of interest and other ethical issues in your practice. Please make sure that you go ahead and review those documents and then submit that quiz for your credit, and have a great rest of your day.